Can we go to the chamber so that I can disclose that? I'm not asking for this to go to the chamber. Also, I will say, as lawyers or as advocates, we are also under duty to protect the judicial officers and protect the students.
I think that is okay. That is okay. I think one way of protecting judicial officers is by disclosing in open court like this what is there.
By being blunt.
Exactly.
Be blunt. You brought it yourself.
My Lord, next time, I hope also don't have to say must tweet within 15 minutes, which is what we were trying, then accusing of not reading everything. Because I have not actually read everything. There are other issues I could also have read. But my Lord, let me read this. My Lord, hearty congratulations to my long-time friend. That was underlined by there. And the source is Right Honorable Amason Tefakingi Ichikechi. The petitioners said the issue, and that is the issue that I picked during my submission, that there is a long-term friendship between the judge and the party. That long-term friendship ought to have been disclosed. I say that. Then it goes on to say, on the occasion of the renewal of your marriage vows with your beloved wife, this is now there, evidence that they are giving. You are a true testimony to the belief that spouses resolve to stick with each other through thick and thin, great things can happen. I wish the two of you the very best in this long journey, and pray that God continues to bless this union and review with wisdom and the patience that comes with marriage and family life. Hongera kakangu. And below there is the photograph where a gift is being given by the Honorable Mr. Kingi, Senator, to the couple or Judge Mlimani and I believe his spouse. That is the annexure that was put by the petitioners in proof of the fact that there is a close relationship, a close friendship that under the law ought to have been disclosed, given that Kingi is a very important party for purposes of the case against the Senate that he botched everything and has come here to defend those impeachment proceedings. I believe my job is done, and because that is all that it says, and that is the affidavit of the petitioners. Unless they need me to read something else,
no, what?
I can sit down.
The second applicant.
May it please you, my lords, my lady.
You are in another file, eh?
No, it can't be.
Or we take it in another file or the same file?
Yes, my lady.
It's not in the same file. Yes.
I am in 509, where we have the application.
509 is in cohort 1, eh?
Yes, cohort 1.
Give us 5.
Your Lordship, with profound respect, permit me, Your Lordship, to indicate that we are arguing the application dated the 22nd of October, with a further affidavit, Your Lordship, having been filed this afternoon through the court's email. Your Lordship, from the onset, it's with heavy heart, Your Lordship, that we have to move you through these mechanisms, and that, Your Lordship, my submissions are the submissions of my client, and that I'm just a vessel for putting across my client's case. Your Lordship, there is a notice of motion that seeks the recusal of this bench. The same, Your Lordship, is supported with an affidavit and an annexure. Equally, the further affidavit is supported by 2 annexures. In my submissions, Your Lordship, I will heavily rely on the facts contained therein.
What's the date of your application?
The 22nd of October, Your Lordships, my lady. I'll begin by indicating and relying on the Judicial Service Code of Conduct and Ethics Regulation 2020, and I draw the attention of the court to Regulation 47. Regulation 47, Your Lordship, states that a judicial officer may recuse himself or herself in any proceedings in which his or her impartiality might reasonably be questioned, where the judicial officer, 1, is a part of the proceedings, B, was or is a material witness in the matter in controversy, C, has personal knowledge of disputed evidentiary facts concerning the proceedings, D, has actual bias or prejudice concerning a party, E, has personal interest or is in relationship with a person who has a personal interest in the outcome of the matter, F, has previously acted as counsel for a party in the same proceedings, G, is precluded from hearing the matter, H, a member of the judicial officer family, has economic or other interest in the outcome of the matter in question. A recusal by a judicial officer shall be based on specific grounds to be recorded in writing as part of the proceedings. Your Lordship, it is my client's the bench should recuse itself on the ground contained therein. Permit me to begin by indicating that yesterday when the court was delivering its ruling, it indicated actual bias on the part of the parties before you, Your Lordship. The petitioners were condemned in a wholesale, in disparaging language coming from the bench, a language that indicated prejudice or bias on the part of the petitioners. It was indicated by the bench, Your Lordship, that despite the heavy submissions, the authorities that we quoted, we were not addressing the bench, but addressing the gallery. It is so prejudiced, Your Lordship, that such perception on the part of the petitioners culminated into the court not even taking note of most crucial issues that we had submitted on. For example, despite the appeal that is now being launched, the court failed to take into notice of the question of delegated authority. It is a considered submission, Your Lordship, that had it not been for the bias and the prejudice that the court has on the part of the petitioners, such would not have escaped the mind of the court. Your Lordship, further, the court made further remarks that they take great exceptions with the remarks of the petitioners. When the court indicates that they take great exceptions with the remarks of the petitioners, it's a prima facie indication that the court has descended into the arena of dispute, and that the court therefore becomes or takes a defensive approach in the manner in which the prosecution of the case is being conducted. Your Lordship, a judge must at all particular time be a solemn person, slow to anger, and of good temperaments. Your Lordship, The statement indicates that the court has taken a position as against the respondents, the petitioners. And the position is prejudicial to the petitioners and erodes their confidence to continue appearing and making submissions before this court. It was the observation of this honorable court, your lordships, that my client indicates that the court made further findings that the petitioners were not pursuing the urgency of their applications. What a reasonable man, a bystander, a fair-minded person, listening to these statements, internalizing them, will come to a conclusion that the court has taken a hard position on or against the petitioners. The test of a fair-minded person, your lordship.
My lord, we really hate to intervene, but my colleague, if he is added time for it, it's okay. But let him tell you how, yes, the ruling you issued would be a basis for an application that was filed long before that ruling.
Your lordship, if he may be patient, you'll have his chance to bite the cherry and respond in that manner he so thinks that he should. Your lordship, the application has also indicated that Justice E. Ogola is closely associated with his spouse, who serves in the Water Kenya Towers agency. The averments of our clients, your lordship, is that this is a matter that ought to have been disclosed at the inception of the proceedings.
Let me get you right. You mean the judge is closely associated with the wife?
That is not my statement.
Yes, what is it that you say? Repeat for the record.
May I repeat for the record? So that the court may not again misquote me.
Proceed.
Your lordship, the spouse of his lordship, one Florence Oluoch Auma.
You deponed to that issue?
Yes?
There's a disposition to that
Yeah,
issue?
there is a disposition to that issue, your lordship.
That Florence is the wife?
Yes, there is.
Paragraph?
Yes, paragraph. Paragraph 13 of the supporting affidavit, as read with paragraph 11 of the further affidavit. She holds a position in the Kenya Water Towers Agency, an appointment that was done pursuant to the Gazette notice number 7515 of 2013, for and on behalf of the presidency by Siopan Tuya. Your lordship, it may go on record that the sixth respondent who initiated or made this appointment is a party in these proceedings, and that the parties.
No, my lord, that's not factually correct.
I'm not getting you right, and I'm sorry for intervention.
Where are you lost, my lord?
Here. If I'm looking at the same document as you,
Yes.
the Gazette Notice 7515 was issued on the 7th day of June 2023 by Soipan Tunya,
That's correct.
Cabinet Secretary for Environment, Climate Change and Forestry.
That's correct.
The sixth respondent in this proceedings is who?
He's the president.
Then, where is the next one?
I'll get there. I'll get there. Your lordship, the cabinet under the constitution is constituted of the president, and the cabinet secretaries appointed there rather, and the deputy president of the Republic of Kenya. that Siopan Tuya is an agent of the presidency. Your Lordship, one of the issues that was before the impeachment was that the Deputy President, the petitioner herein, indicated that Kenya is a shareholding country. There are shareholding agreements before you, and that positions either in parastatals or corporations were to be shared in accordance to that share agreement.
But that is the reason why his client got impeached. That is not anything that is before you for determination. That is the reason he got impeached.
You'll be given an opportunity to respond. Even if you are itching, Mr. Nyamondi, take your call. Your Lordship, it is my client's submissions that Florence Auma Oluoch may have been a beneficiary of that shareholding. Your Lordship, finally, Your Lordship,
Kindly, just
we have...
Just a minute.
It is extremely unfair and unjust, especially for an advocate to mislead or what we have seen to play to the gallery like evidence. Can you read paragraph 12 of the affidavit? So that he does, no.
Yes.
Let's hear it from him, where he says that the said board is chaired by the president, who has... So can you kindly do it properly so that you don't...
I'm sorry, I'm not...
Excuse me. No, excuse me. No.
Hold on.
Your honors, your ladyship and my lords, they will have time, as you said, to respond and say all these things. If he's saying nonsense, they'll stand up and say so. But this constant interruption is intended to derail this hearing. Let them respond when their time comes. Yes.
And
stop bullying people.
And we abhor the condescending nature of the respondents. Everybody here has been instructed by a client either to speak sense or nonsense. So, that being the case, the condescending attitude is completely objectionable. And everybody should take their seat and use their time with the sense. If sense can only come from them, they do it during their time.
Thank you very much. Sir, can I finish what
My
I
Lord,
said?
may I be protected to urge my application and the respondents be granted an opportunity to
Let me
respond?
finish what I was saying.
You will have your time.
I know I will have
to
my
respond.
time, but please, this is the application being presented. Let's not have other things.
It has been served upon you.
You will respond.
Just permit me to say one thing. Just one thing.
Your Honor, if I'm allowed to just say something.
Just a minute, Counsel. Just a minute, Counsel.
Let applicants finish their case and then people will respond. Because this interjections is just going to affect the conduct of the proceedings. It's very unfair. Let everybody have a chance. Each person has 10 minutes, others have 5 minutes. Let them utilize their time. But these objections in between is unfair and it's affecting the flow.
Come to court and say that.
My lords, this is what I want to say.
Order. Can we have some order? Can we please have some order? Harvey, you may proceed.
My Lord, a judge is first, an advocate is second, an advocate. We are all here advocates. My plea is we conduct these proceedings in an orderly manner. As Professor Gidu Mugai used to remind us when we were in school, to be an advocate, you are a superior mortal. Can we just be slightly superior and deal with this thing in an intelligent way?
Mr. Ndegwa, use your remaining time to conclude.
Well, I am most obliged, Lordship. It may be noted that, Your Lordship, that the chair of this board is directly appointed by the President, the six respondents in this case. Your Lordship, may I submit again that the perception out there is that this bench has been constituted for a particular purpose. And that the bench is just a mere conveyor belt, and that the parties herein will not have the chances to have justice of their case being dispensed. Your Lordship, I have annexed a tweet by Senior Counsel Ahmed Nasir, annexed in our affidavit at paragraph 12, and I would wish to read that to your Lordship. Ahmed Nasir, your Lordship, is a senior member of this bar, a senior counsel, and your Lordship, here it goes. The conservatory orders will be discharged by the 3-judge bench, latest by next week, if not by Friday. Even as we approach you, your Lordship, the perception out there is that this bench is part of the conspiracy.
My Lord, may I object to that? Ahmed Nasir is not the law.
Your Lordship.
He speaks not to the law. Ahmed Nasir has also an affidavit. He is not a witness, my Lord. How does Ahmed Nasir, and we have 64 senior counsel, how does Ahmed Nasir, how can his tweet inform submission before this court?
May I answer that, your Lordship, to the good professor, that we are speaking about perception. The standard of a bystander, the reasonable man, a fair-minded man in the status and the character of a senior counsel, Ahmed Nasir says, and the president's lawyer says, we cannot receive justice. That is the standard.
My Lord, Ahmed Nasir says that this court will quash the impeachment of Rigathi. No, but the point is, he then speaks in your favor.
Yes.
Pick that line.
Let him respond. You will not teach me how to submit. You will pick the line that you so wish. For me, I am saying, your Lordship, that the perception out there is that this bench has been constituted as a conveyor belt. Finally, your Lordship, this court will remember that on the 16th of October, we moved the court for a mention on the 18th. The court declined to grant that mention and slated our file to be mentioned on the 29th of October. But when they were moved by parties in these proceedings, the court was generous and gracious enough even to sit on a weekend, to sit on a Saturday. Noting that we were before you, you slated our matter for the 29th, and never saw the urgency. Your Lordship, how can a fair bystander be convinced that this court will dispense with substantive justice? How can it be said that this court is impartial? Your Lordship, the question of a spouse being linked to a judge, as indicated by Rules 47, is of paramount importance and something that cannot be ignored. Why didn't the court disclose to us? Why did the court conceal? If the court can conceal such kind of apparent evidence, what else is it capable of concealing? Your Lordship, permit me to indicate that in our affidavit that would wish to expunge paragraph 16 of our affidavit, supporting affidavit, will not rely on it, and paragraph 10 of the same affidavit will not rely on the same. But the standard, your Lordship, is that of a bystander. Ahmed Nasir spoke, and he has a following of over 1 million on his Twitter handle. That is, the perception has been created to the Kenyans that this bench, 1, is a conveyor belt, 2, it is considered for a particular mission, 3, it's part of the conspiracy. Your Lordship, we urge you to uphold our application and grant the prayers sought. Your Lordship, my learned friend Mr. Masharia will highlight on the authority with the authority in support of my submissions and those of Kibe.
Sorry, just a slight clarification on the expansion. Paragraphs 10 and 16, if I had properly.
Yes, that's correct.
Of the supporting affidavit.
That's correct.
I don't know whether we can do that through oral submissions. You cannot expunge a paragraph from an affidavit as it is evidence before the court, and it has to be considered, it has to be challenged in all ways. Number two, if you expunge paragraph 16,
Can you cover it in your response, please?
I may, but if you expunge 16, I have a problem with that. There is no application before you. If you expunge paragraph 16 from the affidavit, there is no application as being urged before you. So we need all this clarification. Let's not take things lightly.
Yes, Your Lordship, yes, it is true that the paragraph that I seek to expunge is paragraph 16.
Paragraph 16 of which affidavit? By who?
And 16 is
The applicant's affidavit. That is Obuli Namenya.
This is 10, 16 is
My Lord, permit me with
Perhaps, my Lord, again, because we have to be fair to the court, my colleague has to be candid and confirm to the court. The reason he is withdrawing that paragraph 16 is because the claim there is factually false. Because you can't just withdraw and leave the world thinking...
We are not even seeing that paragraph 16. Can you read it, the paragraphs we want to withdraw?
and 10 and 16.
Your Lordship, are you having the same application?
Read as paragraph 10, which we want to withdraw, and paragraph 16, so that we can consider if it can be withdrawn.
It's a lie.
in English.
We give Mr. Deboa, my lords, your leadership, the opportunity to finish.
Yes, yes. Let him read those paragraphs,
yes,
so that we can sit down.
No, I agree. I'm just saying, protect him from these tutorials that he's getting from this.
Order, please. Order. Please read as paragraph 10.
Your Lordship, I wish to say that most respectively, I wish to say no more in respect to the paragraph.
This is a direction from court. Read paragraph 10 and paragraph 16. Read
paragraph 16. Reads,
paragraph 10 first.
May I have some peace, Your Lordship?
No, listen, please, listen.
Who is in conduct?
Listen. Bana Njiru,
Yes, Your Lordship, I agree.
you have applied to expunge
Yes,
paragraphs 10 and paragraph 16.
Yes, Your Lordship.
Can you read those paragraphs which you intend to expunge?
Your Lordship, paragraph 16 says that...
Paragraph 10.
It's the code. It's the code.
And Your Lordship, may I take note that these paragraphs have been expunged?
We have not expunged those paragraphs. It is your application.
Expunged them. The petitioners have credible information that Honorable Mrima is a close associate to the proposed Deputy President, one Mr. Kidore Kindiki, and that the said judge failed, refused, or neglected to disclose those facts to the parties at the inception. The basis of the application to expurge that particular paragraph is on the basis that the same has been linked to the affidavit sworn in petition 015. Paragraph 16, that Lady Justice Mugambi is conflicted as she should recuse herself, as she was Mr. Kidora Kindiki's LLM student at Moi University.
We have no LLM program at Moi University.
Professor you will have your time to submit, sir. And that's why I'm expunging it. That's why I'm expunging this paragraph. That is what my client said. A crucial issue that she failed and or refused to disclose to the parties. My client has learned that she was not an LLM there and that she only took her degree in that university.
We have no objection to anything being expunged, subject to the court observing that if this witness has lied about these two issues, what else has he lied about?
In a ruling, because application has been made and the response is there, but we decline the invitation to expunge those paragraphs. They will remain as part of the record.